Okay, this is breaking news. We have just gotten a hold of a motion from Karen Reed's defense. This is defendant Karen Reed's motion to dismiss. Let's read what this says. It was filed about 3 hours ago. So this is brand new and hot off the presses. Defendant Karen Reed's motion to dismiss. Now comes defendant Karen Reed by and through undersigned counsel, and hereby moves this honorable court pursuant to 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges. And alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Ms. Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. So they're saying the jury acquitted her unanimously of counts 1 and 3, and they were deadlocked somewhere on count 2, either the main count or the 2 lesser included. But they are saying she was unanimously acquitted by the jury of counts 1 and 3, and those counts she should have been found not guilty on those, and that if she's retried on that, double jeopardy will attach. That's the argument. Let's get more into this. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. This case is cited that in this case states, by requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the 5th and 6th Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. And another case says that prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founding fathers saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The Blueford v. Kansas case states the double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. Quoting U.S. Constitution Amendment 5, the clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, hereby subjecting him or her to embarrassment, expense, and ordeal, and compelling him or her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Commonwealth v. Taylor, quoting United States Martin Linen Supply Co. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Ms. Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the 2nd degree. That is huge. That is huge news. That is a huge breaking story. And there is no reason to assume it's not true, because there's an affidavit sworn to saying that this is true to the best of the knowledge of Alan Jackson. Where are we here? Given the central importance that acquittals have held in our criminal justice system for hundreds of years. The defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. So just reading this on the fly without reflection, it seems to say that we want these count 1 and count 3, the murder 2 and the leaving the scene of an injury death, I believe it is. Those should be dismissed because of double jeopardy. But if the court still thinks there needs to be additional factual inquiry into those, we should be allowed to inquire and gather more facts and evidence regarding how the juries were and what they had unanimously acquitted Karen Reed of prior to them saying they were deadlocked. The background: on June 9th, 2022, Ms. Reed was charged via 3 separate indictments with murder in violation of count 1, vehicular manslaughter in violation of this, count 2, leaving the scene of personal injury or death in violation of this law, and a jury trial began. So there we go. Murder in violation. So that was a 2nd-degree murder, vehicular manslaughter, and leaving the scene of personal injury or death. A jury trial began on April 16th. On June 25, 2024, the jury began deliberations. On July 1, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. See Alan J. Jackson affidavit at paragraph 7. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused jury. In short, let's read the footnote here first. While the juror's note, as read by this honorable court, indicated the impasse was on charges, it did not say whether the charges were those within count 2, i.e. the multiple ways to find guilt on count 2, or extended to other counts. The affidavit attached herein indicates the former, not the latter. So it indicates that the charges were in count 2 and not the other counts. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges in the indictments. The following day, on July 2, 2024, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that she or he wished to inform him of the true results of the jury deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, 2nd-degree murder. Juror A was emphatic that count 2nd-degree murder was off the table, and that all 12 jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury death. Another day later, on July 3rd, 2024, Attorney Yannetti was contacted by 2 different individuals, hereinafter Informant B and Informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C. Okay, that's interesting. So the Yannetti was not contacted by 2 other jurors, but by people who had received information from the other jurors. Both of whom are part of the deliberating jury in this case. David R. Yannetti, affidavit 2. Yannetti has an affidavit as well. Informant B sent Attorney Yannetti a screenshot he or she had received from someone, hereinafter Intermediary B, of text messages that Intermediary B had received from Juror B. Okay, so now we're one step removed even farther. Juror B sent text messages to Intermediary B. Intermediary B sent them to Informant B, and Informant B sent them to Yannetti. In that screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Sick. So he's saying it was split in half for the second charge. Interesting. Informant C had been in contact with another individual intermediate. So the same thing for this. Juror C tells intermediary C tells informant C, and informant C passes it on to Yannetti. Informant C had been in contact with another individual, intermediary C, who is a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent attorney Yannetti the below screenshots of his or her text message with intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C, no consideration for murder to manslaughter, started polling at 6-6, then ended deadlocked 4 no, 8 yes. Interesting. So they started 6-6 and deadlocked at 4 no, 8 yes on manslaughter. Informant C, interesting. If it was no consideration for murder too, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the verdict, jury verdict slip that was all confusing. Intermediary C, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. Interesting. 2, argument. Here is the legal arguments behind all of this. The jury's unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. This is the double jeopardy argument, and this is the legal foundation for it. What constitutes an acquittal is not to be controlled by the form of the action in question, Taylor quoting Martinez v. Illinois. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. Commonwealth v. Babb, quoting Martin Lennon. The mere presence or absence of check marks on a form is not dispositive. So they're saying that the fact that they didn't formally mark the check marks, not guilty of second degree murder, does not mean they didn't find her not guilty. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed was not guilty of counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. See Alan J. Jackson affidavit, paragraph 5. A juror was emphatic that count 1, second degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. David R. Yannetti affidavit, paragraph 4, reflecting the text message from juror B. It was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose. Reflecting juror C's statement relayed by intermediary C that there was, quote, no consideration for murder too, and Ms. Reed, quote, should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. The Supreme Court's decision in Blueford is not to the contrary. So again, he's saying that just because it's not written doesn't mean it didn't happen. That you're holding the form of what happened over the substance that 12 jurors unanimously agreed that she should be acquitted on charges 1 and charge 3. So he's saying the form is not important. And the Supreme Court's decision in Blueford is not to the contrary or agrees with that. In that case, a juror had reported during deliberations that a jury was unanimous against the charges of capital murder and first degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. the Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited reprosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the juror's statements reflect a final determination that persisted through the end of the deliberations. Even assuming argument or inargument, and contrary to the foregoing, this court finds that retrial would not be prohibited under Blueford. This court can and should afford broader protection under Massachusetts state law. See Commonwealth v. Tinsley. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but are statutory and common law, having long embraced the same principles and protections. Section B. Reprosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. In other words, there was no reason to declare a mistrial on murder 2 because they already decided murder 2 was not guilty. There was no reason to declare a mistrial on count 3 because they already unanimously agreed she was not guilty on charge 3. So the double jeopardy clause affords a criminal defendant a valued right to have his or her trial completed by a particular tribunal. This is also in Taylor. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Here, Ms. Reed did not consent to the declaration of a mistrial. See Allen Jackson Affidavits, paragraph 9, also Commonwealth v. Edwards, rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. So saying we didn't consent to it, and just because we didn't object to it doesn't mean we consented to it. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. Ray v. Commonwealth, quoting Arizona v. Washington. This rule is rooted in the importance to the defendant of being able, once and for all, to conclude his or her confrontation with society through the verdict of a tribunal she or he might believe to be favorably disposed to his or her fate. Cruz v. Commonwealth, United States v. Jorn, a plurality opinion, means they weren't unanimous. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. See Allen J. Jackson Affidavit, paragraph 8. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Commonwealth v. Horrigan, see also Picard v. Commonwealth. Finding no manifest necessity where no opportunity was given counsel to argue the propriety of the question or the necessity of a mistrial. Commonwealth v. Stewart, finding no manifest necessity where the trial judge first ruled that he was going to declare a mistrial and then almost as an afterthought unenthusiastically asked whether counsel objected. The record is independently lacking on the second prong, as it reflects no careful consideration or alternative to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so, and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel. I mean, you can't bring it up again, to bar the government from relitigating a question of fact that was determined in a defendant's favor by a partial verdict. Quoting these cases, when the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. That's the crux of it here. That's what we've been saying since this all came to light. Even though it's only a partial verdict, if they said she is not guilty, if they agreed unanimously she's not guilty of charge 1 and charge 2, then you can enter those judgments. The judgment is rendered on the counts on which the jury has reached agreement. The Supreme Judicial Court's holding in Commonwealth v. Roth, the court should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. As the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion. Blueford, declining to require court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses, where under Arkansas law, the jury's options were limited to 2, either convict on one of the offenses or acquit on all. Massachusetts law, to the contrary, clearly permitted the jury to return a partial verdict. Okay, so they could return a partial verdict on some, if not all, the accounts. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present where, as here, the jury was asked to return 3 separate verdicts on 3 separate counts. That's important. 3 separate counts, 3 separate verdicts. See Roth v. Mass, a distinguishing situation where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. That's what we have here. We had 3 separate verdict slips. In this circumstance, where the jury reports a deadlock without specifying the counts on which it has reached an impasse, that's what happened here. We have 3 separate sheets, and the jury said it's deadlocked, but it didn't specify which counts. It is a straightforward, memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and or an evidentiary hearing to substantiate the existence of an acquittal. So he's saying, okay, even if you don't think that it should be dismissed and you think there needs to be more factual, one of the facts we have to decide is whether there was an acquittal on any of the charges. So do a voir dire of the jury and ask them. Should the court seek the affidavit of each juror, i.e. jurors A, B, and C, the defendant asks for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the juror had unanimously agreed to that the defendant was not guilty of counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. Commonwealth v. McCallop. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which he was previously acquitted by a jury. And the defense submits that post-verdict inquiry is equally warranted in the present context. Just as the court in McCallop approved questions to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Ms. Reed was not guilty of counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious right to the favorable outcome of a jury trial and to the protections of the double jeopardy clause and its related state judicial protections. In conclusion, for the foregoing reasons, Ms. Reed respectfully requested this honorable court issue the order dismissing counts 1 and 3. That is big. That is big. And we have the affidavits of Yannetti and Jackson. I currently only have the affidavits of Jackson. And let me bring those up, and we will. These are on page here. I have to open this up in a separate. Nope, not there. I have to open this up in a separate window. Bear with me real quick. Open image in a new tab. Then we have to open the second image in a new tab. Right. Okay. This is the affidavit of Jackson. Let me bring it up here. Remove that and bring up the Jackson affidavit. I don't have the Yannetti affidavit yet. We might get that at some point. Here is the Jackson affidavit. Same deal. This was one of the attachments. I, Alan Jackson, declare I am a partner in the Los Angeles law firm of Worksman Jackson and Quinn, LLP, and I have been licensed to practice law since 1994. I am counsel for Karen Reed, docket number, appearing on her behalf in the Commonwealth of Massachusetts pro hoc vice, which just means a lawyer from another state gets the permission of the court to temporarily represent a client in their state. On Tuesday, July 2nd, of 2024, I was contacted by Juror A, true name and identity withheld to maintain anonymity, based on my conversation with Juror A and that juror's description of what she is, where she was seated, and certain identifying information, such as name and occupation, disclosed during the voir dire process. I was able to positively identify which juror he or she was. Juror A told me that he or she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that he or she believes it important to disclose such results because he or she believes that those results significantly impact Ms. Reed's rights. Go to the second page here. Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following that determination regarding count 1, the jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury death. On July 1, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court and without providing any opportunity for defense counsel to be declared a mistrial. Where do we go here? Without providing an opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Neither Ms. Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked. Flat says they were denied that opportunity, including the lesser included offenses, on which count or counts the jury may have arrived at a verdict. Nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse, and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for counts 1 and count 3. Ms. Reed was denied her right to receive those verdicts in her favor. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States and the state of California and the Commonwealth of Massachusetts. Executed this date of July 3rd, 2024 at Los Angeles, California. Well, we also have, we now, due to Aussie Overlord Hayden, he has given us the affidavit of Yannetti. Let's see if we can bring this up here. Let's see, how long is this? Is also 3 pages. I, David R. Yannetti, do hereby depose and state that the following is true. Oh, we have to scroll down this way. To the best of my knowledge and belief, I am an attorney licensed in Massachusetts since December 20th, 1989. My main office address is 44 School Street. We don't need his address here. On January 29th, I'm going to try to make this just a little bit bigger for you. There we go. On July 3rd, on January 29, 2022, I was retained to represent the defendant, Karen Reed, regarding the above captioned matter. On July 3rd, 2024, I received communications from two different individuals, hereinafter Informant B and Informant C, who had received information from two distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. To my knowledge, Informant B and Informant C do not know each other. On July 3rd, 2024, Informant B sent me a screenshot he or she had received from someone, hereinafter Intermediary B, of text messages that Intermediary B had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree and split in half for the second charge. When the judge sent us back with that Hernandez sick thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose, or even thought she hit him on purpose. Sick again. They give us free counseling forms when we left. They gave us free. That's interesting. They gave them free counseling forms when they left. Based on the first name of Juror B given to me by Informant B, I believe I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. And on July 3rd, 2024, Informant C contacted me to say that she personally knows Juror C as they used to work together. Informant C and Juror C also have a mutual friend, hereinafter Intermediary C, who is a current coworker and friend of Juror C. Informant C told me that he or she had posted something about Karen Reed case on Facebook on Monday, July 1st, 2024. She told me that she believes that post led Intermediary C to text him or her and inform him or her that Juror C was a deliberating juror in the case. Informant C told me that she thereafter reached out to Juror C via text message and discussed her experience as a juror in very general terms. They discussed what an exhausting experience it was, and that Juror C was relieved that it was finally over. Intermediary C told Informant C that Juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Well, today, Informant C sent me 3 screenshots of a text message exchange she had with Intermediary C. Informant C told me that Intermediary C was reporting to him during the exchange what Juror C had revealed during the Zoom meeting. The text message exchange read as follows. Intermediary C. No consideration for murder 2. Manslaughter started polling at 6-6, then deadlocked at 4-no, 8 yes. She was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, she voted no because the cause of death was twofold of hypothermia and head injury, of which he or she was convinced that the vehicle did not cause both. The whole jury felt very intimidated by Higgins' presence at the end. Ooh, that's very interesting. I'm not sure who they were talking because Higgins wasn't there at the end. But anyway, it's also sick. It wasn't there. So the whole jury felt very intimidated by someone's presence at the end. She was not sure what she was going to do. She's going to lay low for a couple of days to see where it takes him or her. Hasn't ruled out anything. The jurors all have a group text going. Yeah, that's what I thought. That was the Albert too, not Higgins. Thank you. So apparently the jurors all have a group text going. So the jurors are texting each other, perhaps deciding what they're going to be doing. Informant C Interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. Intermediary C, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung up on, and the instruction paper was very confusing. Informant C, quote, what a great experience for him or her. Amazing that they let the Alberta in that last day. So they let the Alberts in that day. So again, they're intimidated by the Alberts. He, she felt very honored, says intermediary C, to be part of it. He, she was a redacted physical description of juror C. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. Informant C, that's the way it should be. Knew it was an intelligent jury. They will be studying this case in law programs for years to come. I know how not to investigate to try a case. Oh my God, wow, that's kind of what we were saying. If they all agreed on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she is retried on that charge. Yeah, see, this is a random guy coming to the same conclusion without the body of law. Based on the description of juror C given to me by informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror he, she was and confirm that he, she was a deliberating juror. Signed under the pains of penalty of perjury this 6th day of July, 2024, David R. Yannetti. Well, there you have it. That is the motion to dismiss the charges and 2 supporting affidavits from Jackson and Yannetti. I completely and wholeheartedly agree with their legal arguments and conclusions. That's what I've been saying since this became an issue. If the jury unanimously agreed and reached a verdict on any of the charges, she should be acquitted of those charges, and to retry her after a jury of 12 people reached a unanimous decision, that would amount to double jeopardy. I completely agree with that. It's up to us to see what the prosecution files as a response to this and how the judge ultimately decides. But this is a huge bit of information that we didn't heretofore known, and it was only filed about 3 hours ago, coming up on 4 hours now. And there you have it. Let's see where this goes. Wow. What do y'all think of that, huh? I haven't been able to read what you've been saying while I was reading all of that. I apologize for that because I was involved in the reading part of it. It backfired, Paul, you idiot. Wow. Yeah. That's very interesting that they were all upset by Albert being there on the last day. They were all upset, it says. And there we have 3 people saying that the jury had reached a unanimous verdict on count 1, murder 2 charge, and perhaps on 3. That's huge. And thank you for everybody, Brian and Hayden, especially for sending me the info and the documents. That was great. Thank you very, very much for that. They meant Albert. The whole reason I believe they were there that day, there was no reason for them to be there. And I'm glad that the jurors found it intimidating because, as you said, that's why they were there. I still don't understand how the jury could hang on anything. Commonwealth didn't even prove that O'Keefe was struck by a vehicle. Well, at least apparently they were unanimous on murder 2 and then in charge 3. So what they were hung up on was charge 2, which was vehicular manslaughter with the 3 levels. The main charge and then the lesser included. So dang. Yeah. Yannetti has been a lawyer for almost exactly 2 months less than I've been alive. He's been at it a bit. All right. So I was just scrolling through there to see what what some of your thoughts were. And Chloe Albert's Revenge, thank you so much for the super chat. I'd be intimidated too with Brian Albert sitting there looking like Thanos. Thank you for that. Do you think Lally will offer a plea deal, guilty of DUI, dropping all other charges? I don't think so. I mean, right now he seems to want to do it, but I'm thinking that ultimately in the end there will be no retrial, especially now with this cat out of this particular bag. If it's going to look real bad if counts 1 and 3 are retried, and reversible error, I think, is real here if they're not, and count 2, they get, it's going to be rough for them. So I think they're going to want this to go away very, very quietly. They have, I don't know what the time frame is for filing, the formal start of trial, of a retrial in Massachusetts. I know some places like Florida, where the YNW Melly mistrial happened, they had 90 days to restart the case. I don't know what it is in Massachusetts. People are saying Morrissey will probably quit before his term's up. If he's smart, he'll quit tomorrow. Ozzy also heard 12 months, 1 year, and okay, everybody's heard 1 year. So I did hear. I'm going to assume I heard correctly because all of you were saying 1 year. That's a long time to leave somebody hanging. Yeah, the next hearing is on was the 20th. I thought it was the 22nd. But anyway, the 20th, 22nd, somewhere around there is going to be the first of the where do we go from here hearings that are going to be scheduled. So, all right, we're going to have to follow this. That was a wild ending to this day. That was unexpected. And I mean, it was unexpected there would be a motion. And the content of the motion was, that was whatever is more unexpected than unexpected. Wow. All right. Gee. Anything I say here at this point is going to be anticlimactic. So, we got one last super chat. Mags in Florida with the $5. Fit for the rest of Lally's case. Can't wait to see the FBI investigation. Yeah, it's going to be fun to see what happens with that. But mods, thank you so much. Chat, thank you so much for being here. And thank you so very, very much for the generosity, the monthly memberships, the super chats, the gifted memberships, the purchase. Thank you for all of that. And thank you for being here in chat. Vice Squad chat is the best chat ever. Join me tomorrow as we catch up on the Alec Baldwin trial. It's going to be the run up to the Alec Baldwin trial. We're going to look at his police interviews tomorrow night. Tomorrow night for me, tomorrow morning for you. We're going to start a little bit later, probably. Stay tuned. We'll either start normally at 9 a.m. Eastern like normal. We might bump that back to 10 because I have a dinner appointment I have to go to, and I don't know what time I'm going to get home. So stand by for that. Pay attention. It'll be very, very fluid, but we will watch the Alec Baldwin initial police questioning. And then Wednesday, join me for opening statement in the Alec Baldwin trial. All right, let's go say hi to Andrea Burkhart. Go tell them Legal Vices sent you. Bye now. Take care. And I'm just going to do a hard out bye.